This is where the difficulty really, that gets ratcheted up. You spend the night in jail instead of being released Saturday morning. If there's not a judge available to arraign you, maybe you're held Saturday night. If there's not a judge available to arraign you on a Sunday, maybe you're held until Monday, and you're finally arraigned on Monday. So, it's not unheard of to be held for multiple days upon an arrest for a domestic violence. Once you are finally arraigned, the bond conditions are frequently far more serious and far more rigid than your typical misdemeanor. Frequently, you will not be allowed to possess a gun. If you have guns, they're going to be ordered to be removed from your house. Well, that's a problem. It's not a problem just if you're a hunter or a sportsman, but also, quite frankly, if you are a security guard or a police officer or anyone else that has to carry a gun as part of their employment, that's a real problem. I think that most people imagine domestic violence cases frequently occur in the context of drinking. That is actually an assumption held by a lot of judges and magistrates. So even if there's no allegation of drinking in the police report, no evidence that you were drunk when they showed up to arrest you, frequently bond conditions will incur. You can't drink alcohol. You have to attend AA meetings twice a week, and finally that sometimes even that you're going to have to do drug testing and alcohol testing. You're going to have to submit to random PBTs. All of these things are very difficult restrictions on your liberty. In fact, the gun issue was an infringement on Second Amendment right. And so again, different than the normal case, different than the, hey, you're charged with a misdemeanor, we're going to slap you on the wrist and we'll see you next time. All of these bond conditions can make even being charged with a misdemeanor a really difficult process to go through. The last bond condition and the first difficulty in trying to resolve a case like this is you're always 99.9% of the time you are going to have a no contact provision, which means you are not going to be allowed to have any contact with your significant other or spouse. That means no phone calls, no texting, no emails, no nothing. And you're going to have a no contact provision with your home. Where you live, you're not going to be allowed to return there. And I've had many cases, where not only did the complaining witness do what you said, which is try to call the police and the prosecution and say, hey, look, this was an argument that got out of control. Yes, I called the police. I shouldn't have. That was a mistake. I don't want the case to go forward. I want my husband or my boyfriend to be able to return home. I don't want a no contact order. And I want to drop the charges. I've had judges and prosecutors, in fact, more often than not, with the victim sitting in front of them in a courthouse, refuse to amend that bond order